This is Mike Franklin, a property tax guy, and today we're going to get into the situation with our judiciary in New York State pertaining to the recording of assessment hearings. Our judiciary does not want us to record these assessment hearings, but they don't want to provide a logical explanation as to why. And I think it's time to do something about it. I believe I have a constitutional First Amendment right and to freedom of press and to freedom of speech. And what I believe is going on here is what's known as prior restraint. The court is limiting my First Amendment rights, and something needs to be done about it as it pertains to the recording of small claims assessment review hearings. The court system kind of globally applies, their rules to control court proceedings. And then there can be logical reasons for doing that. But the thing is that there has to be a reasonable explanation to limit people's constitutional rights. I've been in contact. I put in an application for audio visual coverage of numerous small claims assessment review hearings, and have been denied basically every time except for once, about 4 years ago. And they cite various rules of the administrative judge, and they cite the New York State civil rights law and New York State real property tax law, and none of which are relevant to what it is that they're talking about. It's what I refer to as self-dealing. They don't want to be accountable to the public. They don't want to be transparent. It's all about a convenience for them. And what they're saying is that that I do not have a constitutional right to record court proceedings. And I agree. There is not a specific constitutional right to video record court proceedings, because in 1791 there was no such thing as video recorders, and so they forgot to put that in there. But what I'm suggesting is that I do have constitutional rights. We all do. We all have a constitutional right to freedom of speech and freedom of press. You don't have to work for CNN to have press rights. All you have to do is be a citizen of the United States. And so basically, I'm going to go through this letter of denial that they wrote me, and I'm going to show you how ridiculous these people are. They lied several times in their denial, and I'm going to review it, and I'm going to prove it to you. So right now, I have the New York State Real Property Tax Law, Section 735, determination not precedent. In their letter of denial, they said, "Dear Mr. Franklin, I am writing in response to your request to record the upcoming virtual small claims assessment review proceedings scheduled for February 26, 28, March 4th, 2025, concerning properties located in Erie County, which is the 8th Judicial District." This particular hearing officer is, as you can see, is in their letter, is from the 6th Judicial District, because the 8th Judicial District wasn't able to recruit hearing officers. Doesn't appear as though they were actively trying, and then they didn't have any, and so somebody from the 6th has to do it. But anyway, the denial letter was written on the 6th from the 6th Judicial District's letterhead. So I'm at a loss as to who it is I'm going to have to sue here. Do I sue the 6th Judicial District, or do I sue the 8th Judicial District? But in any case, the hearing officer is an attorney named Lisa Smith, and I believe she's from the Binghamton area. And Ms. Smith appears to just kowtow to the administrative judge. She has the authority to, make these determinations, but she just thinks that the administrative judge says that they're denied, and that's far from the truth. So let me just read you what she said next. She said, "Real property tax law, Section 735, prohibits recording devices of any kind in SCAR proceedings." Okay, so I've got Section 735 right in front of me. Determination not precedent. No transcript of testimony shall be made of a small claims assessment review hearing. A transcript, trans as in translate, script as in scribe, as in writing. Transcript, translation to writing. A video is not a translation to writing. It continues. The hearing officer's decision of a petition for small claims assessment review shall not constitute precedent for any purpose or proceedings involving the parties or any other person or persons except as provided in Section 739 of this title. Again, 735, determination, not precedent. So what that means is that the cases are decided on determination, not precedent. Therefore, transcripts aren't necessary because there's no case law in small claims assessment review hearings. And let me repeat what she said. Real property tax law, section 735, prohibits recording devices of any kind in a SCAR proceeding. Do you see that said anywhere here in section 735? It's a bold-faced lie. But it's also propagated in their training manuals. The hearing officer manual says something to the effect of what she's saying, and they're improperly citing section 735. If the real property tax law were to prohibit video recordings, they'd have a section separate for that purpose. This section 735 is determination, not precedent. It's got nothing to do with video recording. So that's bold-faced lie number one. Further, she continues, New York State regulations impose specific restrictions on audiovisual coverage of court proceedings. According to section 29.3 of the rules of the chief judge, audiovisual coverage of proceedings in trial courts shall be permitted only in accordance with the provisions of part 131.1 rules of the chief administrator. Okay, well, let's take a look at that. Rule 29.3. Trial courts. Audio-visual coverage of proceedings in trial courts should be permitted only in accordance with provisions of Part 131.1 rules of the chief administrator. Okay, let's go to 131.1. Let me read that to you. In order to maintain the broadest scope of public access to the courts, to preserve public confidence in the judiciary, and to foster public understanding of the role of the judicial branch in civil society, it is the policy of the Unified Court System to facilitate the audio-visual coverage of court proceedings to the fullest extent permitted by the New York Civil Rights Law and other statutes. So New York State Civil Rights Law is Civil Rights Law 52, and that pertains to protecting other people's rights. So if there's other people in the proceeding, like a child or a rape victim or somebody under compulsory testimony, they have civil rights too. So the court has to weigh their civil rights versus the freedom of press. In a small claims assessment review hearing, there are no rape victims, there's no children, there's no people under compulsory testimony. All you have is the assessor and the hearing officer, and they are public officials, and they have no expectations of privacy in a public hearing. These hearings are public, and people can attend them. And so the only difference is they're saying you can't video record, even though real property tax law says nothing of the sort. So what they're saying, so let me continue on. As interpreted by New York courts pursuant to the rules set forth below. So in other words, the court can interpret whatever they want and do whatever they want. Okay, but here's my argument. No, I do not have a specific constitutional right to record public hearings. However, I do have constitutional rights. And just because I step foot in the courtroom doesn't mean I no longer have constitutional rights. That's absurd. Okay, so my argument is that the judge can control decorum in the courtroom, and the court and the judge can deny audio-visual coverage, but there has to be a reasonable documented explanation. So when you're in a limited public forum, which is what a courtroom is, you're subject to time, place, and manner restrictions. So if the court's going to deny me my right to video record this hearing as a member of the press or as a member of the public, they need to identify a reasonable time, place, and manner restriction. And they haven't been able to come up with one. They just cite these rules. And I'll also say that these are rules of the administrative judge. They are court policy. Policy does not trump the Constitution of the United States. State law does not trump the Constitution of the United States. So the state legislature, when they created the real property tax law, they didn't address the recordings of these hearings because that pertains to, federal law. And so it's not their place to be making that determination. So they didn't address it. They just determination, not precedent. That's what 735 is all about. So there's constitution, there's law, and there's policy. So this policy is even below the state law. So if the judge can come up with a reasonable time, place, and manner restriction, then I would have no problem with it. But to say I have no constitutional rights when I set foot in a courtroom is absurd. So let me continue on. She says, Part 131.1 outlines the conditions under which audiovisual coverage may be allowed, primarily focusing on media requests. It does not appear that you are acting as a member of the news media, as that term is defined in section 131.2C. Okay, let's take a look at 131.2C. News media shall mean any news reporting or news gathering agency and any employee or agent associated with such agency, including television, radio and television networks, news services, newspapers, magazines, trade papers, in-house publications, professional journals, or any other news reporting or news gathering agency, the function of which is to inform the public of some segment thereof. Well, I specialize in assessment matters. CNN and Fox don't get involved in assessment matters. The local newspapers or whatever the news agency, online agencies, they might do a story on assessments during assessment season, but they're not specialists in this stuff. I've been valuing properties for 25 years. I've been a state hearing officer, and I participated in hundreds of cases across 38 counties to date in upstate New York. And I regularly and routinely and for years have related assessment matters to the public, like I'm doing right now. And also, freedom of press means that the government cannot regulate the press. So the government is not the ones to determine who's legitimate and who is not. Are they going to say that Fox isn't legitimate, but CNN is, or CNN is legitimate and Fox is not? It's absurd. They cannot make that determination. We all know that. Okay, further, in 131.1C, prohibits audiovisual coverage of any party or witness testimony in any court proceeding. Again, it's a policy. It's not a law, and it's not. And I have constitutional rights. But let's take a look at 131C. 131.1C. Look here. Audiovisual coverage of party or witness testimony in any court proceeding other than a plea or arraignment is prohibited. Now, listen to that. But on A, it says, in order to maintain the broadest scope of public access, it's the policy of the Unified Court System to facilitate audiovisual coverage of court proceedings. And yet, the C says it's prohibited. It doesn't even make any sense. So, it's what's known as arbitrary and capricious. If they are going to, they may have a variety of logical reasons to limit my constitutional right. Now, if I had big TV equipment, or if there were victims who had rights and stuff, they can limit that. But if they're going to limit an assessment hearing, they better have damn good reason for limiting my constitutional rights. It's just arbitrary and capricious self-dealing for their own convenience. Their convenience does not trump my constitutional rights. Let me assure you of that. Okay, what else do they have? What other nonsense do they come up with? I mean, how many lies can you put in one denial? And again, this hearing officer, I don't really, I blame it on her because it's like when you have a cop abusing somebody and there's other cops standing around and doing something and not doing anything about it. It's unlawful. So she's going along with what the administrative judge says because that's where her bread is buttered. So she's going to do what the administrative judge says. But the thing is, it's at her discretion. She's the judge. It's her call. But she damn well better have a good explanation for denying my constitutional rights. Okay, I hope I made that clear. Additionally, Judicial Law 218.3b states that permission for such coverage is at the discretion of the presiding trial judge. That would be her. Yeah, but it's at her discretion. But she can't just do whatever she damn well pleases. If she's going to limit my constitutional rights, she needs to put it in writing, and it has to be reasonable, and it needs to be appealable. And just this, it's so because I said so. Just doesn't fly. We fought a war to get away from that. And people with white wigs used to say that kind of thing. It's ridiculous. Moreover, she continues, the revised virtual proceedings suggest protocols and procedures issued by the New York State Unified Court System emphasize that participants should not record virtual proceedings without express prior permission from the court. So she's talking about a Zoom or Microsoft Teams meeting where I am in my own home recording this proceeding. And to me, it's the same thing. I have every right to record that. And but if I'm going to publicize it, I would have to have the permission of the court. But again, the court would have to have a reasonable time, place, and manner restriction. So I intend to sue the court system and get to the bottom of this. They provided no logical reason. There's no victims. There's no disruption of the proceedings. There's nothing that let's take a look at 131.1. Let's see, audiovisual, which testimony, okay. One of these rules is to restrict the pre-existing. Yeah, listen to this one. 131.1D. Nothing in these rules is intended to restrict any pre-existing right of the news media to appear at and report on judicial proceedings in accordance with law. Such laws as the Constitution. It's funny. So C says audio-visual covers of party or witness testimony in any court proceeding other than a plea and an arraignment is prohibited. But D says nothing in these rules is intended to restrict any pre-existing right of the news media. Isn't that hilarious? What else we have here? Nothing in these rules is intended to restrict the power and discretion of the presiding trial judge to control the conduct of judicial proceedings. And I agree with that. It's the judge's courtroom, but the judge has to abide by the law too. Okay? It's not just the public that has to abide by the law. The judiciary needs to abide by the law too. The supreme law of the land, the Constitution, and it happens to be the First Amendment that we're talking about. The very first one. No judicial proceeding shall be scheduled, delayed, reenacted, or continued at the request of or for the convenience of the news media. Well, I'm recording with a cell phone, and if I didn't tell them I was recording, they wouldn't even know. So it's obviously not obstructing anything. Take whatever steps are necessary to ensure that audiovisual coverage is conducted without disruption of court activities. Like I said, if they don't even know I'm recording it, how is it disrupting anything? Now, the assessor and say the town attorney, they don't want to record it, but why don't they want it recorded? Because they don't want to be accountable to the public. And I would like to have a hearing. They can object to it, and the judge can decide. But I want to know what their objections are. But they don't have a legitimate one. There's nothing more public than assessment matters. Something needs to be done about this. The judiciary needs to be accountable to the public. They need to be transparent, because if they are not, it allows the assessor to get away with things. So the town supervisor and the town board don't know what the assessor is doing, and the public doesn't know what the assessor is doing. And there's 18 assessors charged in New York City for a kickback scheme that went on for 35 years. That stuff, they get away with that stuff for 35 years because the court is hiding, is helping them hide what they're doing. There was a case at Kodak, millions of dollars. But it was going on for years. Finally, they caught up with them. And the Greasetown assessor and this appraiser that was in on the scheme, they both died in jail. There was a case out in Buffalo where an assessor, they should have arrested her, but they just fired her instead. Apparently she was taking care of her friends and family. And assessors routinely violate real property tax law. It's not a criminal offense, but perhaps it should be. And they do it constantly because they know that they can get away with it. The worst case scenario is a violation, which is like a ticket. And but anyway, there's 8.7 million residential properties in New York, and those property owners are interested in this topic, this news that I'm relaying routinely. They are interested in this topic, and they have a right to see it. They paid for this process. They paid the judiciary salary. They paid the assessor. They paid the town, and you're going to hide it from them? It's outrageous. So I intend to sue the judiciary, and I would appreciate any support that I can get, because I got the feeling this is going to take years. I'm not certain exactly if I'm going to directly to federal court on this, or if I'll be going to state court, then federal court. In any case, it's going to take years, I'm sure. So anybody, any assistance I can get with filing fees, with service expenses associated with this lawsuit, you know, it's not for me. It's for everyone in the state to make certain the assessment process is fair and transparent. This is Mike Franklin, the property tax guy.